Welcome back, and it's now time to go in depth. To hang or not to hang? Is capital punishment really a deterrent to crime and violence? That's a hot button topic on most Jamaican lips following an announcement from National Security Minister Robert Montague that he has instructed State Minister Pernell Charles Jr. to consult with a number of agencies, including the Attorney General's office, to determine if there are any legal impediments for the resumption of hanging in Jamaica. The opposition and human rights advocates maintain that the death penalty isn't the solution to ending the scourge of violence affecting the nation. Now, to help us discuss this issue, we are joined by noted attorney Bert Samuels and human rights advocate Susan Goff. Thanks so much for joining me, lady and gentlemen. Gentlemen.
Thank you.
Okay, so let's begin with you, Mr. Samuels. Legal experts contend that hanging will not be resumed in Jamaica based on the UK Privy Council's rulings in murder cases, especially in the landmark 1993 Pratt and Morgan case. Now, how important was that ruling in terms of ruling out capital punishment?
Well, it's interesting. Pratt and Morgan is a very interesting case. It did say that because 5 years or more lapsed between to carry out the sentence, and it wasn't, and therefore the men would have to be placed given a sentence other than death penalty. The Parliament of Jamaica, in passing in April 2011 the new Charter of Rights, tried to rebut the principles in Pratt and Morgan. It said that a person who has been waiting in exhausting all his appeals, they cannot rely on that weight to exclude the court carrying out the sentence of death. So we had that effort on the part of the Jamaican Parliament in the Charter of Rights to counteract the principles in Pratt and Morgan. However, since then, a new principle has emerged that even if a person is found guilty of capital murder, the judge must conduct a sentencing hearing. And in that sentencing hearing, he can only impose a death penalty for the worst of cases. Now, that could be deemed a very subjective test, but that again has become another hurdle that the hangman has to face before he can carry out executions. So that lawyers have concluded that the worst of the worst, and there was a case of the Queen against Perry, in which he killed 3 young girls. And it was said that the judge passed a sentence of death, but did not sufficiently inquire and assess whether that case was the worst of the worst. So if we have a triple murder not making it, and we have forecast that it's going to be very difficult for that threshold to be passed and the death penalty carried out. So as the lawyers will say, the jure, it's on the book, but de facto, the reality is it is not being carried out. That's my statement.
And as you made mention of the earlier case, there was also a recent case which is often referred to as the Trinidad case from St. Vincent and the Grenadines, where the Privy Council, as you noted, ruled that for a person to be hanged, there must be some proof that this murder fell in the capacity of the worst case, or that the offender is not able to be reformed. Now, is it that the Justice Minister, rather the Security Minister here, is it a waste of time then assessing whether or not hanging is credible?
Well, let me tell you, the Minister came under some pressure. He's the Minister of National Security. He has the responsibility to put policies in place and have the police bring in persons and put the evidence before the court. And I think because there's a spike in the amount of killings in the months of April and before March and April, he was really reacting to that and was really getting to a sentiment in a section of the society that supports hanging. But if he got a reality check from the Attorney General and other lawyers that advise the government, you will see that it is not as simple as impediments. These are barriers almost, not impediments for hanging. So that I don't think that it will work. His desire will not be carried out. And remember, we have a separation of powers. The court must be separated from the executive, of which he's a member of the legislature. He can't dictate to the courts what to do, because there's a separation of power issue also.
Okay, Ms. Goff, what is the human rights activist saying about the minister's pronouncement?
Well, I can't speak for all human rights activists, but I think that the minister has been affected, as Mr. Samuel said, by elements of crime and some particular incidents of murder that have led him, I think, to make a call which has been, over the course of time, a common one for politicians and leaders in society to call for when there is a great deal of concern, fear, anger, frustration about the crime problem, that the call for the death penalty seems to be an easy thing to call for. It seems to be finite, definite, and people respond very often in a supportive way when this call is made. But I think what one needs to look at is, if you are dealing with the issue of murder and wanting to reduce murder, is hanging the thing that is going to do that. And in fact, what has been suggested over time is that it is not, in fact, the death penalty itself that has a deterrent effect. It is the likelihood of being caught, prosecuted, and convicted that is a deterrent. So in Jamaica, we have, the police tell us, for 2015, a 55% cleared up rate. And cleared up, according to the JCF, is that they have identified a suspect and the person has been charged. We have an even smaller conviction rate. Therefore, it's very unlikely that if you commit murder in Jamaica, you will even be prosecuted, you will never face the courts, and even less likely that you will be convicted. So it doesn't much matter whether you want to say, have the death penalty. What we need to focus on is improving the investigations, improving the court systems so that the long delays that take place don't take place, and looking at alternatives like the life imprisonment, which is what is offered. So very often when people talk about, well, if we don't have the death penalty, we're just allowing people to walk free. It's not the absence of the death penalty that allows people to walk free or not be punished. It is a justice system that is ineffective, that is flawed. And that is also a very important issue to remember when we are talking about what is an irreversible punishment of death, is that our systems have been shown to be flawed. We have had instances where policemen have fabricated witness statements, have withheld evidence from the court. We have had instances where there have been confessions signed due to physical pressure or forged instances. So I think that we have to be very careful. When we talk about working with a flawed and corrupt system and wanting to exact the ultimate and irreversible punishment of death, which has not in fact been shown to be a deterrent that people claim it is.
Okay, Mr. Samuels, it seems as if the minister probably should search inside for the internal hiccups before resorting or considering capital punishment, because there are so many challenges in the legal system which does not allow somebody who is an offender, who is guilty of a crime, to be caught. So perhaps the minister should look inside and see where it is that he could try to fix the system before resorting to capital punishment.
That's true, because the greatest deterrent to crime is detection. If I think I can get away with what I'm doing, if I think I can intimidate witnesses, if I think that by the time the matter comes to court to be tried 3-4 years, the memories and recollection will end. It means that I can always go and just feel I could get into trouble, do what I wish, and the chances of being convicted are so minimal. If we change that system and make improve on detection, as Ms. Goff has said, we know that it would be a form of deterrent. But at the moment, we're not employing scientific, means to detect crime. It is still we are relying on icy witnesses, and we know how unreliable human recollection or the desire for human beings to not speak the truth is deeper than we would want to accept. So detection is the way to go, not hanging.
What if, Mr. Samuel, staying with you, what if Jamaica and the rest of the Caribbean community, the members that have not yet acceded to the Caribbean Court of Justice, CCJ, what if they were to accede? Would the decision of hanging, as the CCJ made an official position on capital punishment?
Well, I know in Trinidad, for example, they have carried out hangings in the last 10 years, I know, unlike us. So that it is for each Caribbean state with their laws that they are passing, and laws have been passed in some of the territories almost abolishing hanging, and Trinidad is known for its retention. So it is an island-by-island test. When those laws go to the Privy Council, the rulings must be made on domestic law in the particular country. And likewise, if we subscribe to the Caribbean Court of Justice, those very principles of the worst have been adopted by the Caribbean Court of Justice since, so that the barriers are both in the Caribbean Court of Justice and in the Privy Council for the question of, the finality and irreversibility of the death penalty and the resort to the person's redemption, the person's rehabilitation is always going to be an issue because that is settled law now from the Privy Council. So the challenges are great, and therefore, as we have suggested since night, detection is the way to go, not execution.
I'm going to give you the last word. Some Jamaicans at home and in the diaspora listening and watching may say, if not capital punishment, then what? We need to send a strong message. And yes, we have internal hiccups, but probably capital punishment would drive some fear into hoodlums. What would you say to them?
I would say that we have to remember that we have a written constitution. The constitution is the supreme law of the land. And yes, I know there is if you should put it to the vote, there's a strong sentiment supporting hanging in Jamaica. But we must remember, for example, the case of Dixon and Sangster, where persons were convicted up to the Court of Appeal of Jamaica. It turned out that when the Privy Council ordered the examination of a video recording, the men who were convicted and sentenced to hang for killing a police officer, they were acquitted because they did not appear on the videotape. And those of us advocates against the death penalty see that the possibility of human error in a trial, matched to the question of the finality of the death sentence, is something we don't want to go that way. England abolished the death penalty because they had to pardon a man posthumously who was wrongfully convicted. So,
Mr. Summers, I'm just going to cut you a little bit because we are running out of time. To give Ms. Goff 30 seconds to answer that same question. Thank you.
I think that this is what it goes back to send a strong message, make it very likely that anyone who commits murder will be prosecuted and convicted. And the sentences of decades in prison, life in prison, are serious consequences. However, if the state insists on carrying out the death penalty on persons in their custody, then the message that is sent, a strong message, is that killing is all right in certain circumstances.
Okay, Ms. Goff.
That's the message that is sent.
Okay, we have to wrap it up there. Thanks so much for joining me, Ms. Goff and Mr. Samuels.